my suspicion is that the real motive for speeding these up is to increase the number of deportation proceedings that are taking place, which allows the Trump administration to get credit for more removals from the United States. A lot of people have been asking me whether somebody who overstayed their visa can still get a green card by marrying a US citizen under Trump's immigration crackdown. And the answer is yes, but there are some additional considerations that you need to keep in mind when you're going through the process. So generally speaking, in my opinion, if you have a clean marriage-based green card case, now's a great time to apply for adjustment of status through marriage because the processing times are really, really fast right now. We are seeing cases from start to finish get their green cards in like 3 months. And for the majority of my marriage-based green card applicants, that's amazing news. Now, the reason we think that the Trump administration is speeding these up is because whenever an application gets denied, they'll get referred to immigration court to begin deportation proceedings. So my suspicion is that the real motive for speeding these up is to increase the number of deportation proceedings that are taking place, which allows the Trump administration to get credit for more removals from the United States. So although the processing times are fast and it ends up being great news for the majority of my clients, there are also additional risks that are taking place right now. So as I mentioned, a denied green card application is going to result in a notice to appear in immigration court. They're going to begin deportation proceedings if you are not otherwise lawfully present in the US when that denial comes through. So if you overstayed your visa, you're out of status. And if your green card application through marriage gets denied for any reason, you're gonna almost definitely end up in deportation proceedings. We might be able to fix your deportation proceedings. You could still apply for adjustment of status in front of an immigration judge, but it's an expensive way to adjust your status to permanent residence. And for cases that are not super clean, like people who might need a fraud waiver or a crime waiver, or who've just had a really complicated immigration history, like they were waived through the border and they didn't actually have a visa or any proof that they were waived through, that's called a Quilantan entry. We've done a lot of those cases in my office. Those cases are riskier right now because there is a reasonable probability that if the immigration officer makes a decision on the case, that decision could be a denial. So I would probably hold off on a lot of those applications right now unless remaining out of status is riskier than submitting that application right now and ending up in deportation proceedings. It's a case-by-case determination, and we would need to weigh the pros and cons in your case to see what are the chances of success. If we need a waiver, what are the chances that would get approved? And if we end up in deportation proceedings, what defenses do we have available that might be able to offset some of that risk? All right, guys, there's one more thing that I want to quickly mention. USCIS no longer has to issue requests for evidence when they want to deny a case. I've seen applications get denied for really stupid reasons, like people forgot to include one page in like the 80-page application package for the one-step adjustment of status, or they forgot to sign one page, or they forgot to include one supporting document, and some cases have been denied for that. Admittedly, it's pretty rare. Like I still see USCIS issuing requests for evidence, but once in a while, someone will consult with me and say, I forgot to sign this page and I just got a straight up denial with no opportunity to fix it. USCIS is allowed to do that now. There have been policy manual and memorandum updates that allow them to deny cases without requesting more documents. So if you just get really unlucky, USCIS can properly deny your application, which for people who are otherwise out of status is going to result in the initiation of deportation proceedings. So just keep that in mind. Green card applications through marriage are still getting approved. We've had a lot of success with them. In fact, I think it's a great time to submit an application if it's a clean, approvable case. All right, guys, that's the end of today's video. If you yourself are going through the immigration process and you need a lawyer who can help you with your green card, citizenship, removal of conditions for conditional residence, work permits, or deportation defense, which includes like asylum, cancellation of removal, or just appearing at your court appearances to help you along the way, you guys should schedule a consultation directly with me. Puyan Darian. I'm an immigration attorney and I handle these cases nationwide. And you can find my consultation information in the video description below, or go to my website for the direct booking link, darianlaw.com. Thanks so much for watching, guys, and I'll see you next time for another video.